So good morning to everybody. Welcome back. We are ready for this last day of the hearing. I don't know whether prior to giving inviting the experts from Mexico, is there any housekeeping issue that you want to discuss at this stage? Later on, of course, we'll have to discuss extensively other things, but at the very end, I don't know whether now you have anything to discuss.
Gracias, señor presidente. De parte de la...
Thank you, Mr. President. Respondent has nothing to say right now.
Interpretation, please.
Yes, can you hear me? Okay, on behalf of respondent, nothing at this point.
Nothing.
Okay, so we can proceed with the examination of the expert for Mexico, Dr. José Alberro and Mrs. Verónica Irastorza. You are invited to come over to this stand.
Para el registro de la audiencia.
For the record of the hearing, Mr. President, Mr. Gary Shaw will be conducting the direct for our experts.
So you are very welcome, Mr. Alberro and Mrs. Irastorza. Mind both of you reading out that statement that you are supposed to read?
Is this on? Yes. Okay. I solemnly declare, upon my honor and conscience, that my statement will be in accordance with my sincere belief.
I solemnly declare, upon my honor and conscience, that my statement will be in accordance with my sincere belief.
So many thanks. Now you have 30 minutes to make your presentation.
Mr. President, members of the tribunal, we will now go through a presentation that, I'm sorry, I was going to list. Okay. I will present the first part, and then I will ask my colleague to go to the second part. We first have a review of our qualifications. My name is José Alberro. I have a PhD from the University of Chicago and an MA also from the University of Chicago. I am a senior managing director at FTI Consulting. I've had 40 years of experience providing economic analysis in both private and public sectors. I have been an expert witness for more than 25 years, in particular in many investor-state ICSID ruled arbitrations. I was the CEO of Pemex Gas, one of the big 4 operating companies with 13,000 employees, 10,000 miles of pipelines, $10 billion of sales. In that capacity, I was in the board of Pemex Exploration and Production. I was the chief representative of Pemex during the NAFTA negotiations. Before that, I have been an arbitrator at ICSID. I was a tenured professor of economics, and I taught economics in graduate departments in the United States, Mexico, and the United Kingdom. I'm going to let Ms. Irastorza introduce herself.
This is very sensitive. Sorry. There we go. Hi, good morning. It is an honor to be here. My name is Verónica Irastorza. I'm a senior managing director at FTI. I have been a consultant for more than 20 years and providing economic analysis in both the private and public sectors. I have testified under ICC and London court rules before, and I was Undersecretary of Planning and Transition in Mexico. I was also Deputy Director of Planning for Pemex Gas between 2010 and 2011. And I have been a visiting scholar and guest lecturer at US and Mexican universities like UC Berkeley, UCSD, and the Escuela Libre de Derecho. This year and last year, I have been highly recommended expert in international arbitration by the Lexology Index. Thank you.
So our presentation will have 4 sections. One on background, assignment, and conclusion. Another one on our quantification of damages. The third one where we'll talk about the errors in claimant's losses approach. And a fourth one which will highlight some of our responses to Dr. Maness's report. Even though we've gone through most of these very thoroughly over the last 2 years, we still want to highlight things that we consider fundamental for our evaluation. So in 2014, claimants were awarded Contract 821. PEP, which is Pemex Exploración y Producción, paid claimants $48 million for work done from the beginning of the contract to January 2016. In 2017, it rescinded the contract. In 2018, the Mexican Federal Court of Administrative Justice confirmed the legality of the termination, and claimants initiated an ICSID arbitration concerning Pemex Contract 821. Claims related to 2 other contracts, 803 and 804, were dismissed. Claimants seek compensation. We've lumped them in 3 big buckets. Losses associated with the contract 821, where the amount they demand is between 120.9 and 370.3 million dollars. Losses connected with the unilateral finiquito for about $43.2 million and other losses. And on top of these 3 categories, they demand the payment of pre- and post-award interest. Contract, let's talk a little bit about Contract 821. Contract 821, the compensation of Contract 821 was to be carried out via PEP-issued work orders for drilling and well completion. The payments for those work orders were based on unitary prices, which is very important. Claimants bore the responsibility for all the costs required to perform the assigned work, and there were very long and, as you're well aware, detailed catalogs of those costs. Between May 2014 and January 2016, PEP issued work orders for 27 wells and paid claimants $48.25 million for the work done. The contract called for a minimum of 42 wells, so work orders for 15 of those were not issued. Council has asked us to do 2 big things. One, quantify the damages allegedly suffered by the claimants in connection with the tribunal findings related to Contract 821. And 2, to review or respond to the economic arguments made by claimants and their expert. Over the last couple of days, there have been several references to the numerous instructions we were given, and so we thought it'd be useful for the tribunal to be very clear and specific about what instructions we did receive. Per council instructions, we take the minimum amount of work to be 42 wells over the full contract life. Second instruction is our valuation date is November 10, 2021, when Pemex signed the unilateral finiquito. The third instruction is that claimants are not entitled to contract 821 minimum amount pursuant to the Mexican court ruling. And last but not least, pre-award interest is to be calculated on a simple basis. Our assumption is that claimants and PEP, consistent with those instructions, our assumption is that claimants and PEP would have reached a settlement for the remaining wells that had to be completed. Our basic methodology is similar to what Dr. Manas described yesterday, to establish a counterfactual. And so the scope of the settlement is limited to the claimant's losses per full reparation. And we consider that the settlement would have been determined on a lucrum cessans basis, on the basis of lost profits. Our conclusions, and we will get into the details of this, is that when we calculate lost profits based on the 15 remaining wells, with a 10% margin, which is included in the claimant's correspondence, as has been mentioned over the previous 2 days, we estimate damages to amount to $2.7 million before interest. Recoverable losses should be limited to profits after cost, not gross payments. An award based on full contract revenues overstates losses because it ignores costs that would have needed to be incurred to perform the work. In terms of the pre-award interest, we use the risk-free rate. I'm sure we will discuss the basis of that, which is a 5-year U.S. Treasury yield as of November 10, 2021. And as I mentioned, by instruction, we apply it on a simple basis. As a result, the estimated interest as of December 10, 2025 amounts to approximately $140,000. I will now ask my colleague to go through the next sections. I'm sorry.
Thank you. I'm going to start explaining FTI's quantification of damages. Our approach was, as it has been mentioned, to estimate damages equal to lost profits for the 15 undrilled wells. And the profit margin of 10%, as it has been stated, came from the claimants. The recoverable losses should be limited to profits. So that means that those would be after cost and not a gross payment. We relied on field acceptance certificates and work estimate reports that were agreed by both parties, and that's how we calculated the estimated revenue for the 15 wells. It's important also to mention that claimants did not produce contract-specific financial information to allow us to calculate an alternative margin. Okay. So the first step was to calculate the revenue for those remaining 15 wells. So we used the information that was mutually agreed, as you can see on that table, for each specific well that was actually worked on. We had the payment made and the duration. Those numbers came from these mutually agreed documents. So from that, we obtained the average revenue, as you can see there. First, we calculated a total revenue that was calculated for the 15 wells times the 39.2 days and the $46,709 to get to this $27.47 million revenue. And as I have mentioned, these field acceptance certificates that contain all this information were agreed by both parties. To calculate the lost profits, we just apply to that total revenue the 10% margin that resulted in 2.75 million in lost profits. Claimants did not offer evidence to support any alternative profit margin that would contradict our assumed margin. This number was included since the beginning in our first report. So here is the summary table that shows what I just explained. We had the daily revenue rate of 46,000, the duration, the average duration of the actual performance of the contract, that was 39 days, and the number of missing wells, which is 15. So the revenue lost was 27 million times the profit margin, gives us the damages as of the valuation date of 2.74 million. Our methodology, as I have stated previously, relies on evidence directly related to works performed under that specific contract, 821. For the pre-award interest, we used, like Dr. Alberto mentioned, the risk-free interest rate for the 5-year U.S. Treasury yield on the instructed date. That was November 10, 2021, the date when the unilateral finiquito was issued. And this compensates for the time value of money, and the 5-year U.S. Treasury yield matches the relevant time horizon between the accrual date that I just mentioned, in November 2021, and the expected resolution of this dispute by the end of the year. So the annual interest rate is 1.23%, and we were instructed to calculate this on a simple interest methodology. Now I'm going to go through some of the errors in the claimant's losses approach very briefly. And they use different approaches. The first one is the estimated losses based on the minimum amount, which we think that is an overestimation for reparation. Claimants overstate losses by claiming lost revenues instead of lost profits. Gross revenues do not represent an economic loss, since this regards the costs that would have been needed to be incurred by claimants to execute the works. Recoverable losses should be limited to profits, not gross payments, and this is very consistent with the Chorso factory principle that has been invoked by both sides. They also offer an alternative with the maximum amount of the contract, and that is obviously even more overstated. The claim is based on contractual maximum and is not economically grounded. As we all know, Pemex drilling activity had declined sharply by 2014. Now I'm going to briefly state our response to Dr. Manez's report. His report does not offer an alternative estimate of damages. He only recommends awarding the minimum amount, but doesn't do any financial analysis to back this up. He does not consider the cost that would have needed to have been incurred to perform the work in a manner that is consistent with established economic loss measurement principles. He does not present any alternative damages model. He fails to quantify any counterfactual revenues, incremental margins, or present value of the alleged losses. He does not substantiate claimants' economic losses. and does not offer any evidence to contradict the parameters that we use for our estimations. He does not present a supported interest rate methodology either. Like Dr. Alberro mentioned, this is a unit-based contract. It's not a lump sum. So contractual payments were contingent on actual unit-based volumes of the work performed. And we see some examples of the work orders there on the screen. It's really tiny, but they were very specific for the works. And number two, Dr. Manes says that this is a transaction-specific asset, and we don't think is the case. The premise that claimants made that this is irreversible or contract-specific investment lacks evidentiary foundation. This was a 3-year contract. We know that the rigs have a life of 20 years, so it's not asset-specific. For the pre- and post-award interest, they use a 10-year. The claimants use a 10-year bond that does not match the dispute's time horizon. FTI's choice of a 5-year bond matches this relevant time horizon, as I have explained before, between the breach or our instructed date 2021 and the expected resolution of the dispute in 2026. In terms of the pre- and post-award interest alignment, absent proven risk, post-award interest should align with pre-award rate, and of course this is subject to the tribunal's decision. We also want to point out that Pemex cost of debt and peso-denominated rates are invalid. Pemex is not a respondent, and the damages here are claimed in dollars, not in pesos. In summary, we calculated the lost profits on the 15 remaining wells, calculated using a 10% margin stated by claimants. We relied on data agreed by both parties, and we use a risk-free rate for the 5-year U.S. Treasury yield on a simple basis as instructed. The estimated total damages are $2.88 million, and this includes pre-award interest. Thank you.
Many, many thanks, Mr. Alberro, Mrs. Astorza. So now the claimants have the floor.
Good morning.
Good morning.
This is the first time I've cross-examined two people on one report. So is there a specific allocation of responsibility between the two of you so I know who to direct my questions to?
We are fully co-signers of the report, and so I would suggest you address the question to both of us, and we will choose who answers, and only one person will answer. If that is agreeable to the tribunal, if not, we will hear instructions.
Yes, I think it's logical for you to address the questions to them and for them to choose who of them will respond.
As an initial matter, in your presentation, why did you not address your first calculation of your lost profits damage?
Could you be specific? What do you mean?
In your first report, you created a lost profits model based on the unilateral finiquito. You just went through your presentation and avoided mentioning that calculation based on the unilateral finiquito. Why?
As I think Dr. Menes pointed out yesterday, he, in his report, criticized that we used the finiquito and suggested we find another a data source, which we did. And so we used what we consider to be an unimpeachable source. The results are the same. I mean, there's no significant difference.
But there was a difference, right?
Yes.
Dr. Albero, I believe you said on slide 7, when you were going through your presentation, that it was important that the contract is about unitary prices. What did you mean?
Counsel, I don't have, I either need paper or for you to put it on the screen, please. I am at slide 7. Would you repeat the question, please?
Let's look at your second bullet point. On your second bullet point, you say payments for work orders based on unitary prices. And I believe I recall you hearing you say that that was an important topic that you'd like to discuss. What did you mean about unitary prices being important?
What I think is important is that the contractor would receive, the contract specified that the contractor would receive payments only to the degree that it submitted work orders, and that those work orders would be based on unitary prices. Namely that, I mean, to say it very simply, there'd be a catalog of authorized costs. There'd be a column with volumes. There'd be a column with unitary prices. One would be multiplied by the other. Then the number that you would get would be summed across all rows, and that would be part of the payment that was requested. I thought it was important to remind everyone that that's the very structure of the payment of the contract.
So explain to me what's included in a unitary price when a contractor makes a proposal.
I don't know, and I don't have information in this specific case. The claimant has not submitted any information as to how it got to the unitary prices that it suggested. But that's our point here is that the mechanism for the payment rests on submitting a work order, namely documenting the costs it has to incur to generate a certain revenue.
So would you agree with me in your economic expertise that when a contractor is preparing unitary prices, that it would include its investment costs in that pricing?
As a theoretical matter, it would include all the costs that it would consider appropriate, yes.
So would you agree with me that by charging these unitary prices, that's how a contractor would receive a return on its investment?
Yes. And would get a return on its investment only to the degree that it had incurred those costs.
So your report, if I'm assuming it's only for the value of the 820, the loss associated with the 821 contract, right?
Yes.
Did you all consider the loss of the contractor's equipment that it provided down in Mexico?
Not directly, but I take it from our previous conversation. It's already included in the unitary prices that the contractor submitted to PEP and that PEP authorized.
So I'm just trying to piece together your model. It would make sense, your model, if you're going to say there's only a profit loss, that you would also include the loss associated with the value of the equipment, right?
Which loss associated with equipment?
Well, I'm just trying to figure out your model. You presented a model that we look at the 821 contract, there's a loss. It's based on lost profits. Where's your calculation for the loss of the value of the equipment?
I repeat my answer. Which loss?
Were you here when we discussed that there are 10 rigs that claimants had down in Mexico to perform work under this contract?
And is there any document that there was losses about those equipments in the context of contract 821?
I'm going to ask you, where's your calculation for the loss of those 10 rigs?
And I'm going to repeat, what loss are you talking about? Which rig was lost where, how?
So you did not perform a calculation for the loss of the 10 rigs, correct?
I don't know. Until you specify which loss you're referring to, I cannot answer the question.
Mr. Alberto, you said something interesting when you introduced yourself, that you were on the board of Pemex Exploration and Production, right?
I was.
How long was that?
I'm sorry?
How long?
2.5 years, approx. I mean, I don't have the exact dates.
I'm just trying to understand your knowledge. Are you familiar with the contracting process that PEP, Pemex Exploration and Production, goes through?
I am certainly not an expert on it. Some contracts were so important that they were discussed at the board, but I would not claim to be an expert on contracts.
But do you agree with me that Pemex's board has to approve contracts, such as the size of the 821 contract?
I have no information about that. What my previous sentence said, some very important contracts. I know at the time what we meant by that. I don't know if contract 821 rose to the importance to be taken to the board. That's an issue on which I have no knowledge.
Do you have knowledge of whether Pemex had to get the allocated budget for this contract before tendering out for a tender?
I have seen no documents to that effect on file. On the other hand, that's the habitual procedure, so again, I'm not an expert. I would take it for granted that that's the case.
So if I'm understanding your answer correctly, before tendering the 821 contract out, Pemex would have had to get the budget, correct?
Authorized by Hacienda, yes.
And so there would be a document with that authorization, correct?
I don't know if a document or a part of a document, it may have been subsumed in another document. You're pushing the envelope of things. Anyway, I left the board 30 years ago, so if I don't know all the details, you will forgive me. And it is highly contingent on the specific issue. I cannot make statements.
I saw you had a career in the Mexican government. Is that a fair statement?
It is.
Are you receiving a pension from the Mexican government right now?
No.
Good.
No, not good. Sorry. I apologize. Mr. President, I apologize.
No, it's fine. You mentioned a case in your second report called Terrence Highlands v. Mexico. that you were just recently engaged, I guess. Tell me about that case, please.
Sorry, objection. The case is not a public case.
But could you point to the paragraph in the report when that's mentioned, that case is mentioned?
It's in the second report. I don't have the precise pinpoint on it. 1 second. Let's look at paragraph 15 of your second report. You mentioned the case Terrence Highlands v. United Mexican States. You see that? What is that case about?
Sorry, once again, the substance of that case is confidential. Thank you. The existence of the case is not, but the substance is.
Yes, I think that's a fair statement. So you should refer to what is stated in the paragraph, not going beyond that.
Dr. Albero, what testimony are you providing in this arbitration?
In which arbitration?
The arbitration I just mentioned, Terrence Highlands v. United Mexican States.
Once again, I'm sorry to object, but I think that would fall within the scope of confidentiality.
Well, in this case, he's not referring to the substance, but to your role in that arbitration. And to the extent that that can have a bearing on your testimony here, that you can answer.
Yes, Mr. President, I am the quantum expert.
I appreciate that you provide testimony on quantum. I need a little more information, please, about the scope of your of what you've been asked to do for your expert report.
Sorry, Mr. Metzheimer, you mean his work in the other arbitration?
I would like to know if he's providing an expert report on lost profits, and if it has what he is saying in that arbitration has any bearing on what he is saying to you in this arbitration. I don't know.
So you are asking him about the consistency of the approaches he's following in this case and in the other case?
That is correct.
We do maintain our objection that the nature of his expertise that he's giving in that case is confidential.
I think that should be sustained because we don't know and the contents of his report. Even FTI, and we have seen that in many cases, many experts provide contradictory views in different contexts. So that's why personally I think the independence of the expert is a limited one because they need to respond to the party who engaged them. So even if I think we should sustain the objection of respondent.
I'll let you draw the appropriate inferences. So, Dr. Albero, explain to me exactly what your counterfactual is.
Okay, I'm sorry. I was trying to go back to the part of the presentation. Our counterfactual is that, but for the decision of the tribunal, PEP and claimant would have reached a settlement in which, in accordance with full reparation principle, Pemex would have offered to pay the revenues that would have been generated if claimant had performed the tasks necessary to either drill or complete the 15 wells for which there were no work orders, net of the costs in which claimant would have had to incur to carry out that task.
And when you mentioned the decision of the tribunal, you're referring to something called the TFJA, right?
Correct.
Are you familiar with the concept of repudiation of a contract?
I am not a lawyer.
Are you familiar with the concept of repudiation of a contract?
No.
Okay. I'll tell you the definition of it just to see if you agree with me. Would you agree that it's reasonable that a party cannot unilaterally terminate a contract unless it has a right to do so? Do you agree with me on that?
No, I am not. This is a legal question. I don't want to pronounce myself.
So I want to go through some of your instructions that you were given. I notice in paragraph 12 of your second report, you state that you were asked to assume that pursuant to a court ruling that claimants are not entitled to a minimum amount. See that?
Yes.
You make a similar statement in paragraph 28 of this report. Do you see that?
Yes.
What steps did you take to verify this instruction?
I read the court ruling.
Assume we disagree with your reading of the court ruling. Would your opinion change?
I read the court ruling. I don't have a legal opinion on the court ruling. And if you disagree with the court ruling, that's why counsel gave me an instruction on a legal matter on which I don't have the authority to have an opinion. So I note that you disagree and proceed under my instructions.
I see also you were instructed, unfortunately I don't have the site on this, that, and I believe it's in your presentation actually. That the minimum amount of work was for 42 wells over the contract term. What steps did you take, if any, to verify this instruction?
I reviewed the contract and its appendixes.
So you read the contract and you formed a legal opinion?
Not at all. You asked me, what did you do? I read the contract. I became, no, I know the contract, but I don't have any legal opinion about interpretation of the contract. That's why I have a counsel instruction, because I am not a lawyer and I don't consider myself, I don't represent myself as someone who can have an opinion about how to interpret the contract. Doesn't mean I didn't read it, I read it.
So tell me, where in the contract did you find that there was the minimum amount of work was for 42 wells over the full contract term?
Please give me the contract and the appendices. I find the question a little unfair. I think yesterday it was projected there's a table. I don't know right now exactly where it is. If you want me to point you to it, I'll be happy to go through the contract. I don't know it by heart.
We'll pull it up for you.
Thank you. I want to scroll through it and the appendixes, right? May I consult with my colleague to see if she remembers better than I do where it is, so that we can save some time? Do you mind, counsel, or can I do that?
I have plenty of time.
So you don't want me to consult with her?
Please, I want the answer.
Could you scroll down? This annex, please. There.
Great. Point to me the language that says the minimum amount of the work over the full contract term was for 42 wells. And for ease, this is Exhibit C 181, page 5 of 62.
We agree that I am not providing a legal opinion, correct? I took an instruction from counsel. My review of the contract leads me to a place where it says el volumen mínimo a ejecutar del paquete 5 será el 40% del volumen máximo establecido. And when I look at the little figure that's there, there's a maximum of 81 for packet 5, and then it says there's 42 wells for the minimum. So the instruction that I was given is the one that I use for my estimate, and there's information there in that document that you are now showing.
I'm sorry, I got lost. Show me again on page 5 of 62 of Exhibit C-181 where it says that there is an obligation to drill 42 wells over the term of the contract.
That's not for me to answer. It's a legal matter. I don't. Your question is phrased such that I'm going to end up pronouncing myself about a legal matter, and I don't want to do that. I will not do it.
But you just told me you verified counsel's instruction that minimum amount of work was for 42 wells over the full contract term.
Then shall we have a conversation about what does verify mean? I interpret verify to have read the relevant documents that are on file and be familiar with them. I repeat that I took an instruction from counsel, and I am not opining on what you want me to opine.
Did you review clause 45 of the 821 contract when you were verifying counsel's instruction? And this,
I'm sorry, can you repeat the question?
and let's go to the cover page first, please. This is Exhibit C34. I'll represent to you it's the 821 contract. And we're going to go to clause 45. I'll also represent to you that this is the only place that I could find the contract addressing volume of works. You see the title there?
I do.
When you reviewed the 821 contract, did you see any other section addressing volume of works?
I don't remember.
Show me in this clause 45 what you relied upon to verify counsel's instruction about the 42 wells being drilled over 1,402 days.
Again, you want me to make a statement about legal matters, and I refuse to do that.
Could you
I
read?
took an instruction, sir.
Could you read the first sentence, please?
No. Unless instructed by the president of the tribunal.
Well, I don't think you need to, because we can read it out. We can read it, and it's obvious that you intend to mean that the instructions from counsel were in contradiction to the clause 45. And that you have been making that point, but I think it's fair for expert to say that he was working under the some instructions, and he could not challenge those instructions legally, even if he didn't share respondent's opinion. So I think the tribunal has understood exactly what's your point, has understood exactly what's the point of the expert, and I don't think we need to belabor this point anymore.
So, I see that you were instructed as well that Pemex would have, and I believe I'm looking at a quote, that Pemex would have settled the contract by compensating claimants for their lost profits. That was one of the instructions you got. It's from your report, but unfortunately I don't have the exact pinpoint site.
Is it included in these four?
Are these four instructions replacing what you wrote in your report?
No, they are just taking from the report.
What steps did you take? And I'm not trying to trick you. I'm really not. I have written that you were instructed, quote, in the counterfactual scenario, PEP would have settled the contract by compensating claimants for their lost profits. There it is. What steps did you take to verify this instruction?
Now that's our decision. That was not an instruction. We decided that the appropriate way, following the Charso principle, to make claimant whole would be to compensate, to establish a reparation that would compensate claimant for their lost profits.
And I'm sorry, I don't want to fight with you, but it says you were asked to assume that under the 821 contract, then point 3, in the counterfactual scenario, PEP would have settled the contract by compensating claimants for their lost profits. Who asked you to assume that?
I will repeat, I was not asked to assume it. It was our conclusion or decision to establish a counterfactual scenario like that as economic experts and valuation experts.
Did you talk to anyone at Pemex to determine whether they would have settled the 821 contract by paying lost profits?
No.
Would your opinion change if Pemex were to say that they would not have settled the contract for lost profits?
My understanding is that this is a procedure that is brought by claimants against the Mexican state for violations to NAFTA. And so my understanding, not being a lawyer, is that the task of the tribunal, having found Mexico to be in violation of some of the articles of NAFTA and USMC, is to determine a reparation that will meet a certain number of criteria established in international law and that we refer to as the Charso Principle. So I think that that's the overall writing principle, and it would be extremely interesting to have documentary evidence to the fact that Pemex would not have offered or asked or come to a determination that that's the only thing that we're willing to offer. They're the one not willing to offer lost profit, but some other thing. It'd be interesting, but I think it would have to be considered within the overall logic of this proceeding.
And I just want to go back, and I appreciate the admonishment about talking about the contract and your knowledge of it, but would your opinion change if the contract was not for a minimum amount of work of 42 wells over the full contract term? If that was not the obligation?
If I had been given a different instruction, I would have come up with a different method and number, yes.
Just so we're clear, so if the instruction was not correct, your opinion might be different.
An instruction cannot, I don't understand. An instruction is an instruction. You obey an instruction. If I'm given another instruction, then I do a different work.
Okay.
Maybe I work too much at Pemex. It's a very vertical organization.
I'm sorry, to what? I didn't hear you.
I don't know why I need to be ironic. I apologize again, Mr. President. I said I worked too long at Pemex and it's very vertical. And so when I'm given an instruction, I obey. I don't go contesting instructions.
There was a famous saying by journalists, never use irony, because the reader will not understand it. So, only irony.
Thank you, you're absolutely right.
So I want to go to your counterfactual scenario, where Pemex is sitting down with the contractor for 821, and they're negotiating a settlement. And as I think it's fair to say that this would have occurred after the TFJA decision. Had the court said Pemex was wrong, the administrative rescission shouldn't have happened. the contractors and Pemex would have sat down for a settlement. That's the counterfactual, right?
Do you have any document that that's the way things would have happened?
I just want to go back to your counterfactual, and I just want to make sure I'm not trying to trick you. I'm trying to just make sure we're on the same page when I start asking you questions about what would have been considered at the time that Pemex and the 809 contractors sat down for the 821 contractors sat down for this settlement. And first, I'm setting the time frame. We have the TFJA judgment. Assume this TFJA said Pemex was wrong. It should not have administratively rescinded the contract. You agree with me that after that decision, that's when the settlement would have occurred?
Yes.
And I'm going to represent to you that that judgment originally came out on October 4, 2018. So we know it came out affirming what Pemex did. Now we're going to disavowing what Pemex did on October 4, 2018. Fair?
You say you're not trying to trick me, but my impression is we're going to the valuation date. And again, I had a council instruction as to what was the valuation date. So I took the valuation date I was told to take.
I understand your instructions. I'm trying to understand your counterfactual. Your counterfactual is that the TFJA would rule in favor of the 821 contractors. Thereafter, the parties would have sat down at a settlement. And so, I'm just using the dates. The TFJA judgment was October 4, 2018. So they would have sat down for a settlement October 5, 2018, thereafter, right?
I was instructed that the valuation date was November 10, 2021.
I'm not asking you what you were instructed. I'm asking you what would have happened in your counterfactual.
So in my counterfactual, what would have happened is that claimant would have submitted a request in writing for terminating the contract. And Pemex would have analyzed that proposal and come to a determination. And in my counterfactual, what would have happened is that Pemex would have offered, as part of the termination, to pay for lost profits. So I do not subscribe the thought that there would have been a negotiation. It would have been a administrative. I have no way of knowing. All of this is speculation. There's nothing on file, but if I know anything about how things happen in Pemex, there would not have been a negotiation. It would have been an administrative procedure.
So the parties would not have sat down for a settlement?
I don't know if they would have physically sat down or not, but it would have all been done in writing and through the form of an exchange of memos.
So, in the exchange of memos, the parties would have taken into account information available to them at the time while they're negotiating the settlement, right?
I contest that there would be a negotiation, but yes, they would take into account the information they had at the time.
And explain to me what you mean by contest a negotiation.
I think, I don't remember the day, and I don't remember exactly who said it, but someone, to illustrate what a negotiation is, said, if you have a house and I want to buy it, you have a price, I offer you a price, there's a price you want to obtain from the house, those prices diverge, and depending on the power of the two parties, a price may be agreed upon, and then the transaction does occur. I don't think that that's the way things get resolved at Pemex, at least not in my time, at least not my experience. And if that's the way it happened, I think it is for you to provide documents to that effect. It does not match what I know from my experience.
What is your experience of how things get resolved at Pemex?
Not through legal means, correct? Because Pemex has often legal procedures with people that disagree with it. So the way they get resolved is like in any administration. Somebody submits a memorandum, the memorandum is analyzed, the memorandum is answered. I don't know if the proper term is memorandum, a document. I'm not a lawyer, I'm not an administrator. And then Pemex makes a determination, and if the party is does not accept it, there must be some appealing process. I don't know how it is structured, and then you go to court. It's not a negotiation in the sense that we talked about it yesterday in the case of a house.
In your second report, paragraph 71, actually paragraph 70 and 71, you mentioned some documents. Called Acts of Reception, Field Acceptance Certificates, excuse me. And then there's also reference to work estimate reports, if you see in paragraph 71.
I see.
Explain to me how these came into your possession and why.
We requested the documents.
How did you know what documents to request?
Because Those are the normal documents that are used
Why didn't you use them for your first report?
because we use the unilateral finiquito that contain the same information, basically.
What do you mean, basically?
There were minor differences. It was the same information.
Did you talk to anybody at Pemex about these documents?
No.
Let's look at paragraph 57 of the second report. And let's look at the footnote 12. Sorry, 64. And this is just understanding your language. You say in the footnote that the well count in DT1 was updated. You see that? From 41 to 42. What was your basis for saying that?
I don't understand the question.
I'm trying to understand why you wrote that 41 was updated to 42. Why did you say that 41 was updated, that's a particular word, to 42?
It was just a fact of looking at both documents.
So it changed from 41 to 42.
Yes.
Did you ask anyone at Pemex why?
No.
Going back to the counterfactual. Again, we're sitting down. Maybe there's not a negotiation. Maybe the 821 contractor has to send a letter for Pemex to review. What information would Pemex be looking at the time when it received the contractor's letter for this negotiation? Or excuse me, settlement. I appreciate negotiation. I don't want to.
I don't know.
Would they look at other settlements?
Maybe, maybe not.
Would they look at other contracts that are similar to the 821 contract?
Maybe, maybe not.
Now remember the graphic that we just saw from DT1, and we can go to it. Would you agree with me, perhaps they look at what was happening for packet 3, which was the 819 contract?
I have no way of contradicting you. Maybe yes, maybe not.
Do you know what happened with this contract, the 819 contract?
The 819 contract? No, I don't.
So you don't know that it was extended in its term?
So I just want to make sure you're not asking 809, you're asking 819.
I'm asking 819.
Okay, no, I don't know.
So packet 4, which was contract 820, that might have been something that was considered at the time that the parties were discussing this settlement.
They might.
Do you know what happened to contract 820?
No.
So you wouldn't know that Pemex extended the term of contract 820?
No, I do not.
Contract 809. The tribunal's already made some determinations about how it was comparable, so I'm not going to debate your independent review of the contract 809, but would you agree with me, given the timing of when the settlement of the 809 contract occurred, that would also be something that the parties would have considered while they were settling the 821 contract?
They may not.
And did you look, I saw you in your report, you reviewed the 809 contract settlement documents, right?
I read them, yes.
What is your understanding of the payment that was made to the 809 contractor in the as a result of the acta de circunstanciata?
Can you clarify your question, please?
Having reviewed the you reviewed the acta de circunstanciata for the 809 contract, right?
I did.
Okay. You understand that Pemex made a payment to the 809 contractor for not requesting work, not issuing work orders, that concept. Would you agree with that?
Yes.
So what's your understanding of that payment that was made?
I don't understand the expression, my understanding.
What is your understanding of how the parties arrived at that amount for the payment?
My understanding is that Zapata, I'm sorry, I don't remember the whole name, but Zapata submitted a list of items for which it wanted to be compensated, arguing that those were non-recoverable. And so Pemex, using, I don't remember which article of Contract 809, which I think clearly specifies which costs are recoverable and which are not, went through the list, excluded the costs that were considered not to be recoverable and compensated for what was left.
So they used the unitary price process, if I'm understanding correctly. Someone went to the price list for the 809 contract, and they submitted a request to Pemex based on this price list, right?
So I don't know if it's the whole price list or part of the price list. I don't know that, but yes, there was a list of, we want you to pay us this amount on account of this concept.
And you agree with me that that request was made for work that was never performed?
Yes.
Just a question. Now would be a natural time for a good pause if that's
Yes, how long do you think it will take you? 3 hours?
less than an hour.
Then we'll break for 50 minutes, and we'll continue. And then in the next session, you finish. There will be any redirect and the tribunal's questions. Okay. So 15 minutes. So. We are ready to resume. So, Mr. Messheimer, you have your hour, 2 hours left.
Happy to inform it might be less than that. It will be less than that. Let me rephrase. Miss Irastorza, this might be better for you, I think. If I understand the calculation correctly, about the, is it 15 wells that were remaining to be drilled? 15, I'm not trying to confuse, was it 15 wells?
Yes, can we go to what you are referring to?
I'm just referring to your calculation of lost profits, of how many wells were left to be drilled. I'm focusing on
Proceed, yeah.
just those wells. And as I understand it, when I read your report, you took, your analysis was because Pemex had asked for wells in the past, they would ask for those kinds of wells in the future. Is that a fair assessment?
Yes.
When you were doing your report, did you look at Annex DT1?
Yes.
And you understand that there were 39 different well types in DT1?
Yes, that's true, for the whole duration of the contract, yeah.
So it's possible that Pemex could have asked for wells other than the ones that it had asked for in the past.
Yes.
In your review of the materials, did you look at Annex DT2?
Can you go to DT2 to refresh my memory?
That's Exhibit C177.
Okay.
Would you like to scroll through it?
Yeah,
Or?
sure.
Okay.
Please.
We can go, tell me if you want to slow down, you can.
Yeah. Yes, if you want to proceed with your...
I'll go to more pinpoint, page 40.
Yes.
So on page 40, you'll see, I think it's well type 1.26 and 1.27.
Mm-hmm.
And Pemex had planned that those operations would be conducted for 85 days. You see that?
Yes.
Did you take that into account when you were preparing your analysis for the future wells that Pemex would have requested but did not?
Yes, there's others where it's only 10 days. What we use, because it was the best information that we had, the history of the contract, so the average is 40, I don't recall exactly, 1 days.
So no,
Yes.
so the answer is no, you did not consider the 85 days when you were performing your calculation?
That was not my answer, sir.
Do you have something that you can show me where you considered the 85 days for the horizontal well drilling?
I considered this document. This document had been for the whole life of the contract. It was there during the performance of the 27 wells.
But you agree with me that it was possible for Pemex to ask for a horizontal well in one of the remaining wells under your theory, and that work would have lasted, according to Pemex, 85 days.
Yes, it's also possible that they would have asked for one for 10 days. That's why we thought that the most objective was to use the history of the contract.
But not possible future performance.
Sorry?
But not possible future performance.
I don't understand your question.
It's possible that Pemex could have asked for a well type 1.36, correct?
All these were possibilities before and after, yeah.
Did you look at Annex DE3
Yes.
in your review? And if you look in Annex DE3, let's just scroll down. Annex DE3 contains again the unit price that we were discussing before for wells being drilled, right?
Yes.
Did you look at the numbers in DE3 or incorporate these numbers in DE3 in your calculation for the price that would have been paid for the future wells that Pemex would have requested on 15 wells? Did you look at
We looked at,
DE3? Sorry.
we looked at DE3. We used the historical performance of the contract to determine the future.
So you did not look at these numbers in your calculation?
Looked.
I'm not trying to play games with you. You did not consider these numbers in your calculation.
We considered them, but they were not relevant for our calculation.
Okay. Did you ask anyone at Pemex about what wells they plan to drill in the future?
No.
In your first report, I believe it starts at paragraph 48, and we go through paragraph 43. There's a discussion about the maximum amount and claimant's calculation regarding the expectations that Pemex would request work up to the maximum amount. And you all opined about that, and you all had an argument about it wouldn't be reasonable for Pemex to request work given the price of oil. Do you recall that part of your report?
Can you point me to the exact paragraph?
Yeah, let's look at, I think it's paragraph 53.
Okay.
Was this something you wrote or something Dr. Albero? I'd like to ask the author of whoever wrote this section's paragraphs.
We're both responsible for it.
Okay. When you were writing this paragraph, were you aware of clause 16.1 of the 821 contract? And let's scroll down to part C. For the benefit of Mr. Pillay, could you read paragraph C? Because it'll go through the interpreter and help him.
En los casos debidamente justificados por
In cases that are duly justified by PEP, in the event that duly justified circumstances arise that make it impossible to fulfill the contract, among which when the contract is not profitable or convenient for PEP according to the economic model that has been defined, insufficient budget, insecure operating conditions, or unsafe operating conditions, PEP may determine the anticipated or early termination of the contract, communicating in writing to the contractor the effective date of such early termination.
So you agree with me, and I'm going back to your report now. You agree with me that in the scenario where oil prices were affecting the budget, Pemex could have applied clause 16.1C, correct?
this paragraph is about the maximum of the contract. So I think I don't understand your
Well,
question.
Your report tells me that it's rational behavior for the counterparty not to perform under a contract when oil prices fall. Did I misunderstand your report?
I think you are taking this out of context.
Explain it to me.
Let me reread this paragraph. PEP significantly reduced its drilling activity in 2015 and 16 relative to 2014. The number of wells drilled dropped from 538 to 295 and further to 125 in 2016. Under such conditions, it would have not been economically rational to expect Pemex to continue with its original plan and spend the maximum amount under contract 821.
Would it be helpful for you to see the paragraphs around it? I'm sorry about this.
Okay.
You don't have to read out loud. I just want you to remember what was written. Explain to me the concept of Pemex not requesting work because oil prices fell. That's in your report.
Yes, again, we're talking about the claimant's calculation based on the maximum.
Explain to me in your report your understanding of Pemex and its performance under this contract when the price of oil fell.
I'm sorry, I don't understand your question.
In your report, you wrote it was rational behavior for Pemex not to request work when oil prices fell. Do you agree?
I'm going to object because I think she has said several times that the paragraph refers to requesting the maximum.
Yes, I think the objection is right. I think the paragraph refers to maximum amount.
Having looked at clause 16.1 of the 821 contract, do you agree with me that Pemex could have invoked clause 16.1 using your scenario of oil prices falling?
I'm not a lawyer, sorry.
Thank you. I'm done.
Wonderful. Then is any redirect?
No, sir. Thank you.
Now I turn to my colleagues. You want to go first, Alain?
I don't want to go.
I can go myself.
Well, I don't want to go first, but I don't mind to go first. I have only one question. I have not found an explanation for the interest of why 1.23. Why? Where does it come? This figure?
No,
The interest rate, right? You mean the interest rate, correct? Yeah, that's the 5-year bond for US. So it's the risk-free rate, basically, for a 5-year bond, which matches this period.
During all the period?
Between 2021 and 2026.
Okay.
Well, I will continue
I'm
with this.
sorry, to be precise, I apologize. It's per annum. It's for the whole period, but it's for each one of the years.
Yeah.
I'm sorry.
I will start with interest rate because we arbitrators and in general arbitrations are supposed not to discuss much about interest. And that's wrong. We should discuss interest. And then let's start with post-award interest. So the interest to be paid by Pemex if it fails to pay immediately the at least 2.8 settlement amount that it should pay even under your scenario. And let's go to paragraph 98 of your second report. which is the December one, which was mimicked by one of your slides today, because I take it from that paragraph 98, the fourth line say, in the absence of demonstrated risk exposure, the economically appropriate post-award interest rate should, if any, be consistent with the pre-award interest rate based on 5-year U.S. Treasury bond yields. So the award will award some amount of dollars to a claim to the claimants against the Mexican Republic, say $2.8 million in your model. And then you say that if Mexico fails to pay right away that 2.8, the interest rate for late payment should be the treasury rate of whatever is prevailing now, which is not 134, which is a historical rate. But now Mexico would have to pay the U.S. treasury rate applicable today to that delayed payment. And frankly, for me, that doesn't make much sense, because actually the award will be given the claimants a claim against the Republic, not against the Treasury, the U.S. Treasury. So that asset is an asset against Mexico, and the interest rate for delay payment should be, at the very least, the interest rate which the Mexican Republic is paying in its borrowing. That was my first question.
And I fully agree with you. So I think maybe we used an adjective that is a bit obscure, which is consistent. We just meant it to be that it has to take that into account. But I agree, the risk profile changes completely. And so the post-award rate should be different. We did not put our foot down as to what that number should be, but I agree with your argumentation.
So in your analysis, between the pre-award and the post-award, there will be a significant change. The pre-award should be a U.S. Treasury-based interest rate, and the post-award should be a Mexican interest rate in dollars. Is that right?
Yes, something like that. We didn't determine it, but it will look like that. Yes, I fully agree with your argument. So we would have to kind of measure it, discuss it, see that the periods of time. It's a little more complicated to deal with, having done it before. Bonds emitted by Mexico, because they are not all the same in dollars, and they have different maturities, and they have different strike prices and things like that. So it does require a little bit of calculations, but I fully agree with your method.
And by the way, we all know that NAFTA forbids punitive damages. So there should be nothing punitive in any interest rate for delayed payment. But to the extent that the claim that the claimants will be getting from the award of this tribunal, they will be getting an illiquid claim, as opposed to buying in the market a bond, a US dollar bond issued by the Mexican Republic. Don't you think so that it would make sense for claimants to be entitled to some illiquidity premium over and above the Mexican rate for Mexican bonds in dollars?
So that's another complicated question. My impression is that there's data that can be obtained that show that Mexico has always paid the awards given by tribunals. So the measurement of that risk would have to be done carefully. I agree with the method and with the approach. I don't disagree. Getting the numbers in line takes a little bit of work. And that's why we did not go that way.
Yes.
Because we thought that was the prerogative.
But you don't see nothing illogical in the tribunal saying, well, say half a point, 1 point for illiquidity, and illiquidity premium to the extent that the claimants are not going to get a Mexican bond, but they're going to get any liquid claim that they cannot sell. Well, probably they could endorse or they could assign to someone, but that would be difficult. So there might be a case for some illiquidity premium on top of the post-award interest rate based on Mexican borrowing rates.
So
which could be applied.
I fully agree to the notion, and I also fully agree to what you've brought to the conversation, which is that there is a secondary market for these things. Getting data on that secondary market is a bit of a challenge. But I agree with your method.
Yes.
I'm just saying the calculation is complicated.
Yes.
And that's why we didn't go there.
And then let's go to pre-award interest rate. Because in that case, Mr. Manes, I think it was Mr. Manes who in his report says that actually since the day in which the amount was due, which in your report is 2021, Mexico has claimants haven't got paid. And they are therefore entitled to interest rate, pre-award interest rate until the date of the award. But you say that the interest rate should be based on U.S. Treasuries on a no-risk basis. But Mr. Manes makes the claim that the claimants were unwilling lenders. Unwilling lenders, we don't know yet whether to the Republic or to Pemex, but they were unwilling lenders, and they are entitled to an interest rate which reflects the borrowing cost of the one who withheld the payment to claimants. So why are you insisting that the interest rate should be a interest rate risk-free interest rate, meaning U.S. Treasuries?
Because I think that the intellectual experiment is, or framework is, that on that date, claimant would have got an asset, which is the amount of the reparation. And in the counterfactual world, it would have gotten the money. And so what was the one investment that was risk-free, where claimant could have invested its money, and that was risk-free. That didn't imply any risk, and would hold them for 5 years. So the choice of a 5-year treasury bond, which has the same maturity than the 5 years that have elapsed, seemed reasonable, and using a treasury rate seemed reasonable because it has zero risk. I mean, there's no such thing as zero risk, but the minimum amount of risk. You cannot buy something with less risk than that. And any amount above that compensates for a risk that there was no reason why claimant would have chosen. Maybe yes, maybe not. I don't know. So I think the standard is to compensate for the passage of time, and that's the one rate that materializes that the best.
So I think your argument is reasonable when we are talking about WACC and the like, and claimants not bearing risk any longer because they were expropriated or they were. But here we are talking about a payment which should have been made sometime in the past, and which was not, and which will be made sometime in the future. Let's assume that, and I know that that's contrary to tradition because Mexico is a quick payer, but let's assume that Mexico were to delay payment for 1 year. So in your analysis, in the way we have discussed a moment ago about post-award interest rate, that claim of claimants would accrue a U.S. Treasury interest rate for 5 years, from 21 to 26, and from now it would change and would switch, would go up to a Mexican rate for 1 year. And frankly, I would find that arrangement not very compelling, intellectually not very compelling. So the interest rate should be, I think you make a good point. The pre-award and the post-award interest rate probably should be the same. But if the post-award interest rate should be a Mexican interest rate, so should be the pre-award interest rate. Because after all, claimants are going to be granted an asset against the Mexican Republic, who started accruing interest from the day in which it should have been paid, meaning 2021 in your analysis.
With all due respect, I don't think we said it should be the same. We did say it should be consistent. And consistent meant from a methodological point of view such that in one case, the interest rate compensates for strictly the passage of time, and definitely after the award has been granted, it does become then a liability of the state, and that implies a risk profile that is different. But when we said consistent, maybe it's the drafting was poor. We should have either chosen another way of describing it or be more verbose or something like that. But I don't disagree with you with any of your analysis that the risk profile changes, and so the rates have to be different just to reflect the risk profile.
Then let's come to simple versus compound interest. I understand that you have been instructed to apply simple interest because of the prohibition of anatocismo prevailing in Mexico as in other countries. So no interest on interest. That's sinful. And but my question is, does the Mexican Republic pay simple or compound interest in its borrowings?
My understanding is that it pays compound interest.
Even in domestic bonds placed in Mexico?
Even in domestic bonds placed in Mexico.
So I know that you are out of bounds and out of your instructions, but you now would concede that that idea of the interest rate being simple runs against your common sense as a financial expert.
Yes.
Many thanks. Let's come now to the 809 contract and this counterfactual settlement, which would have occurred in 2021 or at any other date. Because when I saw your presentation today and I read your documents, I sort of noticed that there was a missing piece in your counterfactual that you were not instructed to respect, which was that any settlement constructed under your model should not be less favorable than the one obtained by Integradora y Zapata in the 809 contract. And then my question is, do you think that your 2.7 final amount of the award is more or less favorable than the $13 million award, payment agreed between Pemex and Integradora y Zapata back in April 2018? Because I would tend to think spontaneously that is much less favorable, and to that extent, your opinion is not consistent with the real counterfactual. You of course were forced to arrive at that figure because your counterfactual was an imperfect one, was missing one piece, which was national treatment. But I would take it that the result of your calculations are not consistent with the principle of national treatment, which was required under the decision in January by this tribunal, and which should be a key element of any counterfactual scenario.
Calculating reparation for 821 using the method of 809 is very likely to lead us to different results. I was not asked to do it, I didn't do it, and I'll be happy to do it for the tribunal.
I just wanted to add that for the settlement of 809, it was really important to go through in detail to the non-recoverable costs that were specific to that contract for those works, right? And we unfortunately didn't have any of the data that we needed to do something similar. So it was not that we didn't want it to, but we just didn't have the data. It's really difficult to tell the contracts and the investments apart, so it would be challenging.
But at the same time, it was clear that the $42,000 daily rate was created, I would say, out of thin air. And that's why it was labeled extraordinary unitary price to an item which was not foreseen in the contract. And of course, exposed some items were included to justify the 42,000. But we discussed that yesterday during the presentations, well, the first actually Monday, and there's no evidence that there were invoices supplied by Integradora y Zapata demonstrating that they had incurred $42,000 as a daily rate. That was a calculation based on unitary prices, which was not foreseen in the contract. Actually, the contract foresaw something different, and that's why the daily rate for the suspension days during Hurricane Ferdinand was much lower, $1,100, and they went up to 42. That gap, the equipment, the drills, the 3 drills of Integradora Zapata were idle, and no matter whether it was because of the hurricane or because of the lack of orders. So it doesn't make any sense to apply different rates, which suggests that the higher rate, the 42,000 rate, is just a contrivance to arrive at a higher compensation. But anyway, I think, but at any rate, you can accept that your figure 2.8 is less favorable to claimants that had they obtained the same treatment as Integradora y Zapata, if only because Integradora y Zapata, for a much smaller contract, got $13 million, and you are indicating $2.7 million. So sheer numbers make it clear that your proposal is not consistent with national treatment. And you are justified to having done so because you were not instructed to take into account that constraint of national treatment and using the 809 settlement as a significant reference point. So I'm not blaming you technically. You were following instructions, but the problem is that one key instruction was missing.
You know, last night we were reviewing how they went to the 42,000 in more detail, and we saw the differences, right, from what Dr. Alberro was describing earlier, that they had this list of cost, unrecoverable costs. And that's how they got to the 75. And then we have also a list with some where they disallowed some of these costs, very specific, like this geophysical engineer, this trailer, like stuff that just Pemex didn't admit. And that's how they got to the 42,000.
If you allow me a Spanish expression, in Spain, I don't know whether in Mexico, we have an expression which are las cuentas del gran capitán.
We're talking about the accounts of the great captain.
Asked to explain his expenses, and there's a famous poem about that, and he explained for spades, whatever, for another tool, whatever. And I got the impression that the $42,000 was to some extent some cuentas del gran capitán. I'm sorry for the interpreters.
The great captain's accounts.
To translate that expression. But anyway, that response is clear. And let me go now to paragraph 45 and 46 of your first report, which refers to rigs. And paragraph particularly 46, you said, and I read, first, Contract 809 and Contract 821 are not comparable. They differ in equipment, personnel, budget, and contractual length. For example, Contract 809 involved 3 rigs, PMX 3, whereas the claimants, and here's the key word, committed only 1 rig, PMX 805, under Contract 821. As the claimants acknowledge, Pemex requested work from only 1 rig, the PMX 805. And my question is, when you use the word committed in the first phrase, which I just read out, you mean that, in fact, you are being used? Because claimants have argued that they had committed many more rigs, even though 9 of them were not used. And again, let's come now back to economics. In the economic life is full of cases in which you pay for assets that you don't use, but the supplier committed itself to supply them, and so if you book a room and pass a deadline, you don't use it, that's too bad, you have to pay for the room even if you don't use it. Your credit card accrues a commission fee per year irrespective of your use. In electricity rates, you pay a minimum, you pay a fixed amount irrespective of consumption, and that's, you need to incentivize suppliers who commit resources, because they need to be paid, yes, for you to be able to use those resources. So I don't find compelling this argument that to the extent that Pemex decided to use only 1 rig, claimants should not be remunerated for those committed, quote unquote, committed rigs which were not used. How would you respond to the fact that committing a resource deserves some reward, even if that resource is not used for reasons outside the power of the supplier?
Yeah, I think like in theory, this depends on who takes the risk, right? Like, what if they have decided to buy 20 rigs, even though they were not going to use them? You know, it was like who had to decide which equipment to have, and that's like a question for me.
Well, but at the very least, then, the number of rigs required under the contract deserves some reward, even if they were not used. So, of course, if you oversupply something which the client has not requested, and that's typical of credit cards, you get a card that you never asked for. That's clear. But if you ask for some resource, you were given the availability of that resource, and you didn't use it, the supplier can ask for a reward for just supplying, and is in finances a commitment fee. Just committing resources gives the creditor, typically the bank in a credit line, the right to claim some money, because you cannot offer things for free. And if there is what in restaurants we call a no-show, well, you should nonetheless pay as if you had come to that fancy restaurant because you occupy one table.
My understanding was that PEP, when considering granting contract 809 to a certain provider, requested from them that they commit 1 platform for the execution of that program.
8 to 9.
821. 821. I'm sorry, 821. 821. And my understanding is that that the documents on file do not prove that the alleged 10 rigs were directed towards contract 821. So while I agree with your general point that you should pay for availability if that's what you want. I fully agree. I mean, you reserve a room, you don't show up, you pay for it. No lo contendere, no problem. But I don't think this is really a good comparison. And I think I'm making a big deal out of the one rig because my impression, and this is not my expertise, and I reiterate it is not, is that one rig could service about 10 wells per year. And so when you put a minimum of 42 wells over 3.5 years, it's consistent with having one rig. Now, if you're going to go past that, yes, you would like to have other rigs available. But that's why Pemex only required one rig. So I still think there's a difference between the two contracts.
Could you accept that the contract require the claimants to be ready to perform to the maximum? So they were required to be able, they were able to perform the maximum of the contract, either in terms of wells or in terms of amounts, and to do so, they have to have rigs available.
Yes, absolutely. But if I remember well, there's also a clause in the contract that they say they have 45 days to if PEP gives them a work order, they have 45 days to 45 to produce, to bring the equipment to the place where they have to perform the work. And we were told yesterday or the day before, they took them 2 days to transport rigs around. So 45 days seemed like a very generous way. So if they had gotten more work orders, going to the maximum as opposed to the minimum, they would have had a lot of time to bring additional rigs to fulfill those contracts. That's the way I interpret those clauses.
Don't you think it would be too risky for claimants to say, okay, we'll have one rig right away available, and then in case we were to need more rigs because of Pemex demands, in 45 days we would buy them in the market and move them to the place, because of course moving the rig from the Poza Rica yard to the site, well, that's the easy part. The difficult thing is to procure the rig, particularly in a tight market, as Mr. Claiborne explained yesterday. So it was not so easy to get rigs on the spot. You had to have some firm commitment to have them available, and 45 days probably was impossible unless you already own the rig and you had the rig stored somewhere.
This is not my area of expertise. We're going too far out into hypotheticals. I will take your opinion and ruling. I don't think it's as clear a panorama maybe, and certainly if some of these issues were core to the estimate of damages, I would have expected the claimant to provide us with significantly more data in one form or another, so we were not forced into speculating. I apologize, but it's too hypothetical for me.
I agree. We are in a fuzzy territory in which things are not clear-cut. That would be for the parties to have discussed and negotiated. But the problem is that in your commitment, your statement is very clear-cut. So there is no fuzziness whatsoever in your statement that to the extent that only one rig was used, claimants are entitled only to compensation for one rig. That's very clear, your statement, and that's not is probably overdetermining you have said more than you should have, because that's a fuzzy area in which many alternative interpretations are possible. Might that be a fair summary of your view after our discussion?
Yes. If I was to rewrite it, I would go and be much more explicit about the lack of information and the fact that Clement did not provide more information so we could settle these issues. But yes, I agree with you.
Okay, so we come to my last question, which is paragraph 34 of your second report, in which you go into some, if not legal interpretation, you respond to something, or partially, which I asked a respondent in the first day, and I don't recall the response because it was not clear in my mind what was the response. Paragraph 34 of your second report. In our experience, the minimum amount referenced in contract 81 serves as a planning estimate or budgetary authorization ceiling. And my question is, it serves as a planning estimate for whom?
PEP. Pemex.
For PEP. And why would PEP have to include an internal planning tool in a contract with a third party? So that, because it could have been an internal memo of one official from Pemex to another official from Pemex saying, or to the board of directors saying, well, we plan that the contract will run between a minimum up to a maximum. That would be an internal planning tool, but internally to Pemex. But in this case, that was written into the contract. And if that was written into the contract, that means that it was not just a planning instruction, a planning tool for PEP. It had some bearing for claimants.
I would argue that it was a way of telling them that it was within their plans that had been authorized within the structure and had been budgeted by the Ministry of Finance. This is not a private company, right? So it functions a little differently from Exxon or Shell. Pemex is a government-owned, and it's very unclear which of its functions it functions as a bureaucracy and which of these functions it functions. It's not unclear. It's complicated. And so there are things like this where all of the process of coming up with investment projects and getting them authorized and moving them up the food chain and getting budgetary authorizations are quite complicated, tiresome. There's a lot of bureaucracy, and this was, from my point of view, this is a way you inform the contractor that this is a contractor that's fully vetted internally, and there's money for it, and that this is not an idea or a plan in the future. It's something that's going to happen. So that's why I think that language was included.
But that language then might be misleading if you say, well, the contract will represent an amount of between a minimum and a maximum, and you say, well, if we don't achieve the minimum, that's too bad. You don't have any entitlement from that fact, because that. So in consumer law, that would be a case of misleading information. You express that there will be a minimum amount to be contracted. Later on, you don't reach that minimum, and you say that's too bad. I said so just as a planning estimate, but it was a non-binding estimate.
The dollar amount, yes, because this is an open contract, but the 42 wells is a commitment.
Well, no. Here we are talking about dollar amounts.
Yes. So I'm saying that the place where there is a commitment, a strong commitment, that I will carry out a certain thing, is when Pep said, I will, I mean, it's almost like a gas contract, take or pay. I will pay for 42 wells, whether or not I actually give you work orders for them. But it's in wells.
Yes, but then this clause on amounts, dollar amounts, should have been written into the contract, because they were at best misleading. If that minimum was not binding, it was misleading information. Consumer protection laws would consider such clause completely misleading. If you say, we are going to spend a minimum of, but if you later don't, of course, the consumer can say, you misled me into believing that there was a minimum.
I cannot argue with the lawyer of your statute on a legal matter. I can tell you, as someone who lived in that world, what my reaction is, but I'm not going to contest you.
Then you would admit that that sentence in paragraph 34 doesn't make sense. The planning estimate. Planning estimate, an internal planning estimate, is not written into a contract with a third party.
Okay.
And if it's a planning estimate relevant for the other party, I mean the consumer, or in this case the claimants, then it's binding. Otherwise, it's useless and misleading. So probably I have understood you completely, Mr. Alberto, and I think we don't need to continue into any legal discussion. You, Franz, by now you have a question.
I looked through my questions, and all of them were responded in the cross-examinations of parties,
Okay.
and the last one from you.
Any redirect on either side concerning this?
We do not.
Okay.
Just
So, yes, please.
Just very briefly, Mr. Albero, Ms. Astorza, you were asked about the paragraph that used the word committed, with the rigs being committed. I apologize, I don't have the 46 of the first report. If you could bring that up. I don't. If you need it, we'll bring it up. But I just wanted to ask: have you seen any evidence that the 9 workover rigs, not the PMX 805, but the 9 workover rigs, were purchased specifically for the 821 contract?
No, we have not.
Thank you very much.
This brings this testimony to a close. We really appreciate your testimony, Mrs. Astorza and Mr. Alberro. And then we'll have a break, because for housekeeping issues, the tribunal will have to tell you about its plans, and probably for that we will like to reflect for a while.
Yeah, sure.
And
We can take a break.
Yes.
Half an
So,
hour.
shall we take a break for 30 minutes rather than 15?
And Mr. Conti, I'll raise a question when we get back, or an issue when we get. It's not really, shouldn't be controversial. So.
Señor presidente, si pudiéramos plantear.
Mr. President, if we may ask the tribunal a question, I think this would be very useful to the parties if we could have the tribunal's first draft of your questions. And the first question that comes to mind is, will the parties, after this hearing, receive a list of questions that should be addressed in our post-hearing briefs, or will the parties need to harvest, so to speak, those questions that have been asked during these days?
Besides, the tribunal But definitely you will get questions. The question is, and I will give hopefully some hints about the type of questions that we'll be asking, and then we can discuss about the planning. But definitely by sometime in March, as early as possible in March, you will be getting questions, definitely. So we are ready to give you some preliminary views of the tribunal on the next steps. And as I said before, we had the break. It's clear that the tribunal is going to send to both parties a list of questions which consist of two things. First, two main topics which would be rather broad, but in the tribunal's view are important. Because in the award, the tribunal needs to define what I could describe as a counterfactual acta circunstanciada for a contract A21, or counterfactual finiquito for A21, assuming that the breaches had never occurred. And in that topic, in that question, the tribunal will define some guidelines which will not be for the parties to change, but on other aspects, say number of rigs or the like, it will be for the parties to make their own reflections. So it will be a mix of a predetermined scenario by this, with mandatory guidelines from the tribunal, together with some open variable elements in which you will have some scope for discussion and make your own case. And the second additional big topic that the tribunal will be asking you to respond to is you need to help the tribunal to reach finality in this dispute, meaning that once the award is issued, there can be no Damocles swords hanging around on anybody's heads, and particularly on claimants. So this should be final. There should be no need for a new round, a new arbitration, and we know that that's going to be the case. You are going to help us, because we know that definitely claimants want finality, as Mr. Finley made clear yesterday. And we also know that, as Mr. Bonfiglio expressed, Mexico is a treaty-abiding country. So it wants to stick to its commitments and to the rulings of this tribunal without allowing Pemex to do things which run counter to the findings of this tribunal. So I think you will definitely be helpful in finding ways for this award to be final and settling this thing forever for both parties. In this connection, in this second connection, finality, and as an exception to the principle that we wrote into the rules, parties will be allowed to mention case law, because one of the things the tribunal is unhappy, is not satisfied with the parties, with either party's position on the question of finality. On the case of claimants, because they are asking for the money first, even if they are not finally requested to pay that money. So that's not satisfactory, as a respondent has clearly expressed. But the tribunal is not satisfied either by the respondent's attitude, that is essentially, that's stupidity. It's a pity, but NAFTA doesn't allow you to do anything. So to enforce your views on the Dorama bond, it will be up to the benevolence of Pemex to decide whether it pursues its claims in Mexican courts for the litigation cost and for the Dorama bond. That's not satisfactory for the tribunal either, because that would not translate into finality. There should be final decision on the issue, and it will be just for the parties to, for a respondent to pay whatever is decided, but no further issues. And that will be the two key, not questions, topics that the tribunal will ask you to express your views, particularly in connection with the first one, the counterfactual acta circunstanciada, the counterfactual finiquito. Of course, You can ask the support of your experts if need be, but the tribunal will not be seeking neither individual expert reports, so you cannot attach another expert report to your post-hearing brief, nor are we asking the expert to sit together and prepare a joint report. Even though if you want to talk to each other, that's fine, but that's not mandatory. And even though I mentioned that possibility just as a pure possibility, I think we decided not to ask for any joint report, at least at this stage. So, and something important is that, of course, beyond those two topics and some ancillary, not many questions that the tribunal may mention, of course, as in any post-hearing brief, you will be able to make any argument, present your case as you wish. So these questions from the tribunal are supplementary questions to any issues that you want to raise in your post-hearing briefs. Then, practical issues before I give you the floor. The tribunal had mixed feelings about number of pages. I'm personally very much against limiting the possibility for parties to, because I like I like relatively accurate and conscientious briefs, and I read fast. Other people maybe, and that's very common for shorter. Anyway, the post-hearing briefs should be as crisp and as short as possible. But as Einstein said, you should simplify, but as much as necessary, but no more. Well, here is exactly the same doctrine applies. You should reduce the number of pages as much as possible, but no more than necessary. And subject to your views on number of pages, the tribunal doesn't have any strong views either way. And then as to the timing, we are in your hands. As I said, the questions are going to be out sometime in March. Then the transcript will be agreed by you probably in a few weeks. So I'll give you the floor for comments on these preliminary ideas that I have launched. I don't know whether the Clements want to take the floor first.
Those were great. I just wanted to raise, if you'd like.
You have an additional issue, yes.
Well, it's not really an issue. It's just if it would be helpful to you. In our opening and prior to, we submitted as evidence some of those Q&As, questions and answers from the bid round. I am happy to share with you the entire packet because I don't want to be accused of piecemealing things. I'm happy to share. If anybody wants them, I'm happy to share what I have. In that line, I'm also happy to share the contract that's packet 9 and packet 10, to the extent that there was argument made about the distinctions between those contracts. I'm happy to share what I received in response to a transparency request in the contract, the corresponding contracts 825 and 826. But that is completely up to you. If you'd like them, I'm happy to share them with everybody. I'm fully transparent.
Well, probably in his comments, Mr. Bonfiglio can also address that idea as well. Please, Mr. Bonfiglio. In general, no, sorry, on this topic.
Thank you, Mr. President. If I may have 10 seconds, please.
Gracias, señor presidente.
Thank you, Mr. President. Two matters should be very clear in the transcription of this hearing. First, that document C226. It's the one labeled as Q&A by us. I will characterize it in the following way. It is a collage of pages turned into an 18-page PDF. And today, at the end of the quantum hearing, we thank the claimants for recognizing that fact. So out of a universe of hundreds of pages, that C226 exhibit was created. And it's very important for the tribunal to be aware of that. At the same time, we acknowledge the claimant's offer. We have no problem with receiving those documents they mentioned, but it would be the third time that in a sporadic way, the claimant before a hearing or almost at the end of a hearing seeks to introduce new documents into the record. That should be clear as well. And it shows a rather erratic way to conduct a procedure of this kind. But we are willing to accept those documents.
Lord.
It was my mistake. No, I was asking Mr. Bonfilio whether his acquiescence extends to the package referring to the other contracts, which Mr. Mersheimer mentioned.
Es buena pregunta y le agradezco.
It's a good question, and I thank you for it, including the contracts. We don't want this to turn into a Pandora's box where you introduce bids related to the contracts, just the contracts. So to recap, the minutes, the records from the meetings, which is C229, not C26. I'm sorry, I had made a mistake. We would agree to receive that, and also we would agree to receive the contracts that the claimant offered to show today on the last day of the hearing, the contracts.
What are you referring to? Could you elaborate a bit?
Yeah. I'm referring to the one that Mr. Shaw spoke about in Mexico's opening, and its packages 9 and 10, which are contracts, shorthand, 825 and 826. And I will warn you about these bid things. It's not hundreds of documents. It's in the thousands. So there's a reason why you were shared extractions. It was to save everybody's sanity, but I'm fully happy to download them, put them on a box site, up to you.
No, but sorry, concerning the packages, Mr. Bonfilio refers only to the contracts. So we could get...
I will give you what I received from the government of Mexico in response to my transparency request. I will not continue to be accused of selecting documents to share with you. I will give you the little file that has all the, I think it has the contract, all the agreements that were made to the contract. I don't want to be accused anymore of any type of picking and choosing, because I'm not doing that.
But you could be accused of submitting too much evidence too late. So you concentrate on the key documents.
And if you all don't want it, that's fine too. It's up to you. I just want you to have what you think that you might need.
Why don't we settle with Mr. Bonfilio's proposal? You just provide those A25 and A2 whatever, just the contracts, nothing else.
Una cosa que
Another thing that would be interesting to look at would be that transparency request, or what would be considered the equivalent of a FOIA request. We'd be interested to see that document. And also, the universe of documents mentioned regarding the Q&A, but you're absolutely right, Mr. President, just the contracts that were not submitted in time. And I want to make it very clear that no discussion regarding national treatment can be opened up based on that. This was discussed a long time ago. It's a pathology that we've seen, if you pay attention, by the claimant. And I think we've been quite reasonable, but this is the third time this happens.
You are interested in the entirety of the questions and answers, so the enlarged version of Article C 229. And concerning those contracts 825 and 829 or whatever, just the contracts, but not the 100 pages, the 1,000 pages for each contract.
I'm fine, but just to avoid a future dispute, when we say just the contract, do you mean just the body of the contract? Or I'd rather give you all of it because I don't want to go through to I'll give you what I got. Because sometimes I got a DT1, sometimes I got a DT2, sometimes I didn't. And I just don't want to fight anymore. I'm
Señor
tired
Presidente,
of fighting.
un comentario.
Just a comment, Mr. President. It's not clear whether this is a time when the claimant wishes to submit new evidence in accordance with the procedural order 1, trying to talk about exceptional conditions. We don't understand if they're doing that, or is this an act of good faith and cooperation, trying to show what they discovered at some point during 2025 or 2026. We don't know what they're referring to, and there's no clarity in what they're offering. So we understand that they don't want to be accused of hiding information, as they say, but what they're doing is very unclear. It's ambiguous. We don't know. We don't understand. As a matter of good order, I think we would say we thank you for this offer, but we're not sure that this is the appropriate moment to flood the tribunal with new information.
To the expanded questions and answers, no submission concerning the 2 or 3 additional contracts.
Estamos de acuerdo en recibir eso.
We agree to receive that, but we don't agree that it should be part of the record until we have a chance to see it.
Enlightened by claimants as to the contents of that second group of documents, and then you would give it clearance or lack of clearance depending on the contents, because that's clear that now is not the time to submit new arguments or new evidence. I understand this is just a response to a remark made by respondent yesterday, the day before, Monday.
Vamos a reflexionar.
We'll think about it. I think ideally, and this would be our proposal, again, we thank you for that comment. We will think about it, and we'll get in touch with the claimant.
For the 2 parties to talk on this, and we decide accordingly. Incidentally, I recall that it would be helpful to have a consolidated and redacted complete version of C-182, which is also a composite document with many different pieces. And then on substance, on the plans that I have just described, I don't know whether my colleagues want to add any nuance to what Alain, you want to add something which I missed in my explanation of what the tribunal is likely to present you in March?
No, maybe I would try to clarify a bit in a Cartesian way that what is important is first that you feel free to draft post-hearing briefs, because I think it's very important for a tribunal, whoever it is, to understand what are your final view after exchanging. Personally, I would rather like that we fix a limit, because I think no limit encourages you to copy again and again, and I promise we have read that, not maybe thousands of annexes, but we have read certainly your views. So personally, I would think that 100 pages should be a great maximum, and there is no need at this stage to have much more. But my understanding is my colleagues and certainly my presidents are against being too strict, but this is, I suppose, nevertheless an indication that we can share. And of course, what I think is crucial is that you remember that we have agreed an award, and that you should sometimes I had the impression, a bit less than I feared, but nevertheless, that you want to re-plead the case as such. I think really what is important now in the briefs is that you stick to the tribunal has decided. We know what are the breaches. We know, or you should know, what are the damages. Sometimes I have been a bit frustrated, I must say, during these 3 days. But so you should really try, I think, to make in line breaches, damages, harm and damages. And then we will find our way. I would also try that you should help us in the calendar, in the agenda. Are we in a hurry? Are we not? After all, it's more your business than ours. But it might be interesting to have the views of the bodies and things like that.
Many thanks, Alan. So I give the floor to Mr. Mersheimer on the next steps, and what are your views on the ideas that I explained before, and your calendar, the calendar you have in mind for the response of the parties and for the submission on costs and the like?
We would like to have this concluded as soon as possible. So the shorter the time frame, the better. And all of your suggestions are well taken and well understood.
And then Mr. Pamphilio.
Señor Presidente,
Mr. President, 4 comments. First, rest assured that the respondent will attempt to work with claimants to prepare the C-182, and it is important that the tribunal has this as soon as possible. Secondly, regardless of the fact that we're waiting for the questions by the tribunal, I think that the parties can work to review the transcripts based on procedural order number 1. We have 45 days. I am going to exert some pressure on the secretary of the tribunal. If we can receive the audios and the draft versions of the transcripts by tomorrow, I believe that with no issues, and this is a proposal that we have not presented yet to the other party, I think that we can have this within 30 days, and clearly this is something that we will be discussing with our colleagues. Secondly, as to the post-hearing briefs, how long? Well, just talking, we'd like to discuss this with claimant, and if we think of the first phase, we had 68 pages, that the first memorial, up to 96 pages as a buffer to develop the questions proposed by the tribunal. I think that this is a reasonable number, but the parties will have a discussion so that we can offer you an agreed number if we get there. When? I think that we might need some time. I would say right now that 45 days after having the final transcript could be something reasonable. But once again, we are going to approach claimants to try to get to an agreement and have a mutual decision. And the 4th comment is about the cost statement. We think that there is a big difference between submission and statement of costs. The statement of costs is, for us, a letter with a chart, with a breakdown of the items, as we did before. Why? Because in our opinion, It is not necessary to have another round of submissions justifying the costs. Whatever is in the briefs is already said. Whatever has been argued in the hearing is okay, and I think that the tribunal does have the elements to determine the assignment of costs. What do I mean? After the post-hearing brief, our position is 2 weeks after that presentation of the post-hearing brief, the parties could be presenting the statement of costs. Clearly, please do let us touch base with the other party to agree this, and if we do not get to an agreement, the respondent will submit their position to the tribunal for a decision. I believe that these are the 4 outstanding issues.
Muchas gracias, señor Bonfiglio.
Thank you very much, Mr. Bonfiglio.
As I said in the tribunal's instructions to you, it would be allowed for you to present case law on some specific issues, very specific issues, say implied powers of a tribunal, just to give you one example. But I understand that you think is necessary, is just enough to have the final post-hearing briefs, and that's it. Which I think is so. No new evidence, of course, can be presented with the post-hearing briefs. But in the post-hearing briefs, there will be the possibility for the countries, for the parties, to offer case law or legal authorities on some very specific issues. And as a case in point, I mentioned the question of implied powers of the tribunal.
Creo que esperamos a la retroalimentación.
I think that we are waiting for claimant's feedback.
I have no problem with giving one piece of paper with the costs. You all have seen and can decide how you want to decide. I have no problem with any of this. I mean, no problem with new exhibits. Sounds good.
No.
En cuestión de las autoridades legales.
As to legal authorities, we understand the openness and flexibility of the tribunal. As to new evidence, we understand that you are not expecting any new evidence, but procedural order number 1 does include a very specific provision that can be triggered by either of the 2 parties if there are exceptional circumstances, and that would need to be justified, and we make a note of that, Mr. President.
To our secretary, in case there is anything that we need to settle at this stage.
No, nothing. The audios will be ready tomorrow.
My colleagues, anything else to add? No? Well, a final question to the parties is concerning the procedure, whether you have you want to raise at this stage any complaint or reserve your judgment on anything that has happened during this process, or you are perfectly happy with the way in which, until today, this arbitration was conducted?
No, nothing here.
Señor Presidente, gracias por.
Mr. President, we thank you for the question, and we understand that it is part of the tradition in arbitration to pose this type of questions. We thank the openness and of the tribunal when asking some questions. We also understand that you do have the willingness to listen to the parties and also understand the parties and explore some doubts that come to mind. We are not going to take some questions as indication of a presumption of a result or of a conclusion, but we understand that the tribunal has listened to the experts, has read the briefs, has listened to the parties, and they will be considering the outstanding issues that we have in the decision on jurisdiction and liability for the issuance of the final award on the one hand, and secondly, they will also take into account the lack of evidence and also the non-fulfilled burden of proof by claimant. Beyond that, on behalf of the delegation of Mexico, we really appreciate the work of the tribunal, ICSID, and we also recognize the presence of our counterpart, and we also recognize those who do not monopolize the mics. They are the younger ones, the younger counsel, co-reporters, and interpreters. Thank you all.
What is important is that the award will not surprise you. You may dislike it, but not surprise you, because that's very clear. The tribunal should give you the opportunity to challenge any views that have been expressed so far by any members of the tribunal, including myself in my questions. And we keep an open mind. We have some inclination at this stage of the proceedings, but we still maintain an open mind. And definitely what you can be sure is that the final award, and that's why we have asked so many questions here, and why we will ask additional questions in writing, not to surprise the parties, and for the parties to have the right to defend themselves and challenge any preliminary views that they have perceived in the members of the tribunal minds. So I bring this to a close with many thanks to our interpreters, who have been doing an excellent job, as well as with the co-reporters. I don't know, I never know where they are sitting.
Just in front.
Ah,
The other way around.
Sorry, I thought you were hiding behind some screen. And there was a technician which helped us, Mr. Tomas. He's the one hiding behind the screen. So many thanks, and it has been a pleasure to chair these hearings for 3 days, and we declare these proceedings closed. Thank you.